They didn't think they were doing anything unusual. Just another purchase, another piece of paper, another ordinary business decision. She signed. They shook hands, and everyone moved on. But months later, when the machine failed, a sentence she never read became more powerful than anything she believed. This is not a story about fraud. There was no scam, no hidden villain. It's a story about contract and what the law hears when you put your name on a page. In the early 1930s, in England, a woman named Miss Lestrange ran a small tobacco shop. She sold cigarettes and rolling tobacco. Modest, practical, ordinary business. To improve efficiency, she decided to buy a cigarette rolling machine. A salesman visited her shop, demonstrated the device, and offered a standard written contract. Nothing unusual, no pressure, no urgency. She signed the form. She didn't read every clause. She didn't analyze the legal language. Like most people, she assumed the document reflected a normal purchase. That assumption is where this story begins. At first, the machine seemed acceptable, but over time, it failed. It jammed. It didn't work as promised. Miss Lestrange stopped using it and contacted the seller. She expected repair, replacement, or a refund. Instead, the seller pointed to the contract. One clause stated that all warranties, express or implied, were excluded. In plain language, that meant this: even if the machine didn't work, the seller had no responsibility. Miss Lestrange argued she had never agreed to that. She hadn't noticed the clause. She didn't understand it. But the case went to court, and the judges asked a different question. Not, was the deal fair? Was the machine defective? But, did she sign the contract? Under English contract law, a signature carries a powerful meaning. It signals agreement, not to intentions, but to written terms. The court ruled against her. No fraud had occurred. No misrepresentation was proven. She was bound by the clause, whether she read it or not. The judge stated a principle that still governs contracts today. When you sign, you are bound. This case, Lestrange v. Graucob, became a cornerstone of contract law, not because it was dramatic, but because it was ordinary. That's what makes it unsettling. No bad actors, no obvious injustice, just a mismatch between human expectation and legal reality. The law doesn't protect what you meant to agree to. It enforces what you signed. This rule exists for a reason. Without it, contracts would collapse under endless disputes about intent. Commerce depends on certainty. But certainty has a price. We all sign things we don't read. Terms of service, employment agreements, leases, business contracts. Most of the time, nothing happens until it does. This case leaves us with a quiet, uncomfortable question. What obligations are you carrying simply because you once trusted a signature? Because in the eyes of the law, paper remembers what people forget. Thanks for listening.